from a corporate point of view. So what I see is most structures and legal documents were put in place when a business was really in its infancy. It started off. However, businesses have grown, new owners come in, new employees, customers, you may even change your product range and service range, and risks basically come into play if the structure and documents don't keep pace with the changes you're making. The question is not really one about whether you've got contracts in place, it's whether your structure and your contracts still reflect the business as it continues to grow and as it operates today. So what I feel and am seeing in my practice is the 5 things that businesses should have at top of mind in 2026 are things, well, starting with firstly the business structure itself. What worked in the beginning may not be the appropriate structure for the business today. The second thing I think is important to look at is the governing documents. So whether it's a partnership agreement, a unit holder agreement, a shareholder agreement, I see a range of issues from having no agreement in place to agreements drafted at the outset where the business was very different and the people were very different and then they're forgotten about. I'll then go through some, contracts, supply contracts, customer terms and conditions. Again, written years ago, do they suit the business as it is today? The issues I often see here are, again, old terms and conditions that suited a business some time ago, haven't kept pace with legal updates. I often see, or clients tell me, the original document was downloaded from the internet or drafted by, or what we're seeing now is drafted by AI. Again, is it appropriate for the business? Also, finally, leases. Evelyn will take you through those documents. All of these documents are important, but unfortunately rarely feel like a priority when everything is going well. The old, if it ain't broken, let's not fix it. So to give you a bit more context to those specific areas, I'll start off with business structure, as every business should probably start with. The hottest topic in 2026 that I'm seeing in my practice is the proposed tax changes that were announced earlier this year. The key change that's probably attracted the most attention in this space is the 30% minimum tax that will apply to taxable income of discretionary trusts from 1 July 2028. I've been fielding lots of queries about this, and I don't profess to be a financial advisor or tax lawyer, but we do know that, or we're basically in fear that the old family discretionary trust and the good old bucket company may be a vehicle of the past. If changes are required in this space, establishing new structures, seeking financial advice, refinancing, all of this takes time and costs money. So the best advice I can give you at this stage, given we don't have the full detail, is keep communicating with your legal and financial advisors and stay on top of these changes because restructuring may be needed. Other things I see from poor structuring, probably the best way for me to illustrate this is to give you some more stories. So I acted for a franchise network a few years back, had all its assets in one company, including all its IP, important trademarks, franchise agreements, leases. It ended up in a huge dispute and arbitration with an overseas master franchisee, which saw the franchisor being sued by that master franchisee. It lost that arbitration. It ended up being wound up and the network being sold. Lesson to be learned from that one is, had the international business and even the IP been in a separate legal entity, the Australian operations may have been able to have been saved. Another war story, another favourite, a retail client with 45 retail stores, all in different companies. This complex structure was devised years earlier and made pre-sale due diligence an absolute nightmare. It ended up a really long sale process, expensive and difficult to manage. So structuring is an important factor to take into account. It should be planned in the first place, but it should evolve as your business evolves. Moving on to the governing documents. The time to build your exit strategy, believe it or not, is before anyone wants to leave and right at the beginning. The way we see shareholders agreements, unit holders agreement, whatever that structure may be, is it's a bit of a corporate prenup. They need to explain the roles, how decisions are made, what happens if owners can't agree, is there a workable process if someone wants to leave, how you value that someone's interest. We're often involved in oppression claims and even a just and equitable winding up, which that's the legal term. What it pretty much means is it's the corporate equivalent of a divorce without a prenup. So having good documents that evolve with your business is really important. Supply contracts, I mentioned that earlier, they really should be in writing. Never ceases to amaze me how many clients have handshake arrangements. And I'm talking some of the sizable clients as well, big or small. Remember, a handshake offers very little protection when a supplier's factory burns down or they go bust or there's a global crisis. I also see, unfortunately, unwritten or outdated arrangements which leave you equally exposed. The other day I was speaking to a client who said, I was asked to sign this contract and I simply accepted its terms because it was a bit of a David and Goliath situation. I felt I had no choice. Again, a contract should reflect your business and your needs. Get advice. Not everything is not negotiable. Customer contracts. These are the old good, T's and C's. Template consumer and small business contracts should now be checked for unfair contract terms. The regulator, which is the ACCC, has made it clear that their enforcement priorities include looking for unfair contract terms. Unfortunately, what I see in my practice is that these laws aren't being taken seriously. What everyone in the room should understand is the mere presence of such clauses is actually unlawful. And since 2023, November 23, they should be taken seriously because significant penalties apply. The penalties are the greater of $100 million, 3 times the benefit derived, or 30% of adjusted turnover. So getting this wrong will make legal fees associated with an unfair contract term review seem cheap or will pale in comparison. Also have a think about payment and security arrangements. These are critical in an economic climate where customers are taking very long time to pay, and we're seeing record numbers of insolvency. You may think you're protected because you've got a retention of title clause in your contract, but that does little other than say you've got title. It'll probably be worthless if you haven't protected your interest by registering on the Personal Property and Security Register. So what should businesses do? You don't have to rewrite your contract every year, but you pretty much should identify what contracts you have in place, how old they are, and have a real good look at those contracts because they basically form the legal foundations for your business. Where we often see it come to a head is when someone wants to sell their business, and then it's a mad scramble to get all these documents in place. Are key agreements signed and able to be found? Can they be transferred easily to the buyer? Does the business own the really important assets? In terms of what I see usually as part of a sale process is due diligence exposes significant gaps which end up costing or ending up with a reduction or negotiation for a reduction of purchase price, and I've even seen a deal be killed as a result of things that have come out of due diligence. To give you some real life examples, buyers, lawyers have identified things like a missed wage rate increase, cost one buyer or one vendor or client $200,000 in purchase price. Key customer contracts with change of control clauses, letting customers walk away if there's a sale of the business. And then even contracts that say that, can't assign the software or the IP license. All of these are examples, real life examples of where we've ended up in a renegotiation and a significant reduction in the purchase price. So key message I can give you is probably get your house in order well before issues arise and well before a buyer comes knocking at your door. In terms of a key asset, as I said at the outset, brand is one of the most important assets of a business, and I will now hand over to Louise to take you through some of the issues we're seeing in 2026.